Okay, welcome to chapter 29, which focuses on the types of authority that exist within agencies. So there are two types of authority. There is actual authority and apparent authority. If you had to take a wild guess, I hope that you would guess that actual authority is authority that's actually given. So it is actually confirmed. It is no questions, ands, or buts. A principal told you that you have the authority to act and do X, Y, Z. Apparent authority, however, is authority that's given to an agent by actions by the principal that would lead the agent to believe that they have authority to act in a particular way. So, or could reasonably lead a third person to believe that an agent does have an authority to act. What effect does terminating an agency have on authority? Well, if you fire your agent, they no longer can act on your behalf. Just like if you terminate an agency, your partner can no longer bind the partnership. Ratification. Ratification is a concept that you have learned about before when we spoke about contractual authority. If you remember, in my scoreboard was about ratifying an act. So ratification is, let's say you don't have authority to act or do something, but you later on do it, and the principal allows you to do it. So to give you an example, I told my agent, my agent works for me, I'm a business owner, and I have my employee works for me, and I told her that she could only order supplies from the ABC company. I needed these particular supplies, and I needed them from the ABC company. Well, my employee decided to use the XYZ company to order the supplies. She did not have the authority to order from XYZ. I didn't have an account with them. However, once I found out that she did in fact order from them and that we did have the supplies, I ratified her actions. She didn't have the authority before, but then I said it was okay. And so then I allowed it to happen and I consented to it happening. So it wasn't allowed first, she did it, then I said, oh, it's okay. So that's ratification. Don't worry about the fundamental rules of contractual liability. Okay, vicarious liability when it comes to the theory of respondeat superior. The theory of respondeat superior. So if you want to impress your friends that you're actually learning during quarantine, you can ask them and say, hey, do you know what the theory of respondeat superior is? Well, it's let me tell you. And it actually means let the employer respond. And that means that it should sound familiar to you with another principle that we've heard of in the past. And it means that an employer will be responsible for the actions of their employees so long as it's within the scope of employment. Where have you heard that before? Where one person will be responsible for the actions of another. You've heard it before. Think about it, okay? And write it down when you do know. So again, so long as an agent is acting in the scope of employment, the responsible party will be the employer. Think back to the example I gave you in chapter 28, which was about the painter that went to get his laundry or his dry cleaning rather than going to pick up paint. Okay, so keep that in mind. Okay, there's an interesting case in your book. It's, I think, the only one I have highlighted here in chapter 29, and that's Rubin versus Yellow Cab Company. It's an interesting case, and it talks about the scope of liability. I'm not going to tell you here what it's about. This is a case I want you to look up, and you need to know the facts of that case. It's a pretty short case, so read it. This is part of your assignment. So the stuff you're supposed to be doing, whether or not it's on your exam, it's part of your assignment for the week of May 3rd. So Rubin versus Yellow Cab Company, it talks about the issues that come up and the scope of employment and when somebody is responsible, when an employer is responsible and when they are not responsible. So that's Rubin versus Yellow Cab Company. A lot of fun, a lot of fun. And actually, those are the only things I want you to know for chapter 29. So I'm going to keep going with chapter 30, um, business associations. This might actually benefit you in real life. Maybe you can pay attention. I don't know. When you're looking to start your own business, there's a lot of things that you'll have to look through, and there's a lot of things that you have to keep in mind. And are you going to start out as a one person? Are you going to do a solo proprietorship? Are you going to have a partnership, meaning it's you and one other person? Are you concerned about liability and lawsuits that would come to you? Do you want to protect your assets that you've already spent building up and have a shield that protects your family and your assets from the company's liabilities? Do you want to be a completely separate company? Do you want to have bylaws? Do you want to have ease of use? Do you want to have stocks that are traded on the market floor? Do you want it to be a family company, a closely held company? So what about taxes? Who's going to pay the taxes? Is it going to be you that pays the taxes? Is it going to be the corporation that's going to pay the taxes? Who's going to do all the paperwork? Who's going to do all the management? Who's going to be responsible? There's a lot of things that you actually have to think through when you are thinking about starting your own business. And so these next couple of chapters talk about those things. It's about starting your own business and actually closing your own business, okay? So when we talk about the factors that influence the type of company or corporation or entity that you're going to start, we look at the ease of formation. How easy is it going to be for you to actually start up this company? The federal and state income tax liability, external liability, meaning who can sue you from the outside world, management and control, the transferability of ownership, and the continuity. Okay, how long is this business going to last? Is it going to be end with me, or is it going to go on perpetually, meaning forever? And one of the most important factors that people look at is the tax implications. Is it going to be taxed at one level, the company? Is it going to be the corporation that takes it all, and then it's going to pass on taxes to the individual shareholders, the individual owners? And so when we talk about the tax implications, recognize that it is one of the most important factors in determining which entity you're going to open up. And so if you are in fact going to have your own business, what you should do is you should have somebody legally there to kind of walk you through all the legal stuff, but you should also have an accountant available to answer your accounting questions. I don't know anything about accounting, so I'm not going to tell you anything that I don't know. But if you are actually thinking about having your own business, those are the two components that you definitely want to have on board. So let's kind of go through them, a couple of the things that are the more important ones. If you are a solo proprietor, meaning you're selling things on eBay or on Etsy or on Amazon, or you have your own website, a blog, you're making masks right now and selling them, or some kind of service, chances are you're probably not going to set up a corporation, a full-fledged S corp, right, or a C corp. Why? Because you're doing something small that's really just on you. The income may not be dramatic that warrants you doing a corporation with the state of New York, like incorporating yourself. You doing bylaws, it's only you who you're protecting yourself from. And again, the type of business that you're doing, there's probably not too much worry about lawsuits at that point. So if you're doing a solo proprietor, it's just you, yourself, and you. It's usually unincorporated. It is one person that runs everything. So there's no formality. You're not going to hold a meeting with yourself, right? It's just you. There's not going to be anything filed, and it's you as an individual that declares it on your taxes as to whether or not you bought stuff, sold stuff, whatever that is. And then when you die, your stuff is, your business is gone. Now, when we talk about a partnership is also a general partnership. A general partnership is unincorporated. It's made up of two or more people, and the purpose is to make profit. Again, there's no formality there, and there's no paperwork filed with the state. Keep in mind that these things here written in this textbook that you're using are generalities for most of the several states. Different states have different laws, which brings me to a point. I want you to know the things I am teaching you that are coming out of my mouth. When it's exam time and you're coming up with all these random things that you found on the internet, if they don't apply to the things I've been teaching, I'm not giving you credit for it, because I want you to focus on reading the textbook, which has been chosen for this class, and the stuff that I'm teaching you, not the world wide web, which has a ton of stuff, and I can't vouch for the truthfulness of it. Okay? Anybody can post anything on the internet. It doesn't mean that it's true. And that was completely evidenced by some of your responses on the exams. Okay? So just keep that little tidbit in mind. General partnership. Okay? When we have a partnership, each partner has a right to control. So each person can bind the company with the actions that they take. So if you're going to get into a partnership with somebody, make sure you trust this person, that you know them, that hopefully they won't screw you, and that they're going to be as much of a hardworking individual as you are. A joint venture is a little bit different than a general partnership. It's again 2 or more people who combine their skill, money, efforts for a particular purpose. A limited partnership, you've probably seen those initials some places, LP, limited partnership. An unincorporated business with at least 1 general partner and 1 limited partner. It can elect not to be taxed as separate entities, where the partners can then be taxed directly. So they have a choice. If it's a limited partnership, you can decide whether or not that partnership will be taxed, whether the individuals will be taxed. Depends on your income, depending on your forte, depending on all that stuff will determine which is the best course for you. LLC, limited liability company, the most common type of entity that is actually made. A limited liability company actually gives you the best of both worlds. It gives you the protection from predators, like people who are going to sue you, and it also gives you management control of the business itself. So the owners are allowed to control the business, work the business together, and there's also that shield that protects them from any liability. LLP, don't worry about that. And then corporation. A corporation is a completely separate entity from its people. It is a completely different animal. The corporation gets taxed at that level as a corporation, and then the people who get profits or money or whatever it is from the corporation, they also get taxed. It gives you the greatest shielding of liability because it's a corporation. It's treated as if it's its own separate person. It has nothing to do with you. A corporation can be traded publicly or privately. Yeah, corporations and LLCs, yeah, I'm sure you know somebody that is in one, or look at, all the big conglomerate companies that exist around you. Duties amongst partners, I mentioned this before in chapter 28, I'm going to say it again. Fiduciary duty, duty of loyalty, duty of obedience, duty of care. You have to be faithful to one another. It is a relationship. You can't screw the other person. You have to act in the best interest of your entity. And you're also going to be sharing in the profits and the losses equally unless it's written otherwise. And I always stress in this part of the lecture, the semester, that bylaws are extremely important. Why? Because the bylaws it's an internal document that allows you to hash out all the different things that should be discussed with you and your partner before you actually start your business together. Everybody has dreams that they're going to have a business, that it's going to grow, and they're going to be filthy rich from it. But you may not think about, well, what's going to happen if this business fails? What happens if I put in more hours than my partner? What happens if I'm constantly putting money to keep this thing afloat and he's just screwing around? What happens if I die? What happens if the creditors come after us? What happens if we want to bring in a third partner? All those questions should be answered and thought about. That way there's a plan in place for if any of these contingencies happen. And that's why it's important to get a good attorney. Not so much to fill out the corporation paperwork. That's pretty simple. You can get that online for the New York State. Like you can get it online, like for the corporate website. But it's really just about thinking about all the different scenarios that can come up and being able to work them out. One of the cases I worked on in the surrogate's court was a case where it was a closely held company. We're going to talk about closely held companies later on. And it was two families. And those two families owned 50% of a really, really, really big company on Staten Island. So this company, we'll call it Company W, and then this company, we're going to call it Company B. Now in Company B and boy, it was 4 partners. So here is 4 partners, and Company W had 4 partners. So we have a total of 8 people that are managing and controlling and owning this company all equally. 50%, 50%. Now out of the B company, those 4 partners, one of them died. Now this person, when he died, he had a partner, same-sex partner, and he left everything to that same-sex partner. So the same-sex partner wanted to now get his share of this company. The other 3 remaining people offered him $1 million to go away. First he accepted, then when he went to an attorney, the attorney was like, why would you accept $1 million when quarterly there were dividends being paid of almost $400,000. $400,000 quarterly dividends to each person. Let that sink in. So this thing was litigated for years. And there had to be a value on the company. The 3 partners that were here, in their bylaws, in their contractual agreements, there was no stipulation or there was nothing in place for what happens if one of them died. If there was, it would have cut down on years of litigation. So those things happen. If it's not clearly spelled out, you're going to expect to be in the court system for a long time, because when it comes to money, everybody wants to fight, okay? So just make sure profits, losses, work, allocation, all that stuff is spelled out, and that concludes all the stuff I want you to know for chapter 30.